$51 billion. That's how much is spent annually due to alcohol-related crashes. Now, every 51 minutes, a person is killed by a drunk driver. And every 90 seconds, someone is injured due to a drunk driving accident. So it's no surprise that states have gone to great lengths to make sure that they keep drunk drivers off the road. Now, before we go any further, it's important that we just take a step back and take a look at the Fourth Amendment to the United States Constitution. And the reason is because this is very important in the context of drunk driving, especially when we're talking about breath tests or blood tests. Because breath tests and blood tests have been deemed by the Supreme Court of the United States as searches pursuant to the Fourth Amendment. So the Fourth Amendment reads, "The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized." So the pinnacle of the Fourth Amendment is that it prohibits unreasonable searches. If a search is reasonable, the Supreme Court has held that a warrant won't be needed in that circumstance. And from that analysis has emerged a number of exceptions to the warrant requirement of the Fourth Amendment. So one of these exceptions is actually a search incident to a lawful arrest. And you listening to this, even if you know nothing about constitutional law, you probably have either seen or hopefully not, but maybe have been involved in a situation where after someone has gotten arrested, they're immediately searched. And this is called a search incident to a lawful arrest. So you get pulled over, there's probable cause to arrest you, and all of a sudden, once you're arrested, the cop then searches you, searches your body, to see if you have any sort of evidence that has been left behind, maybe goes through your car, goes through your trunk. In certain circumstances, this would be okay. Other circumstances, it wouldn't be. But generally speaking, a search incident to a lawful arrest has two purposes. First, to ensure officer safety, and second, to ensure the preservation of evidence. So a search incident to a lawful arrest allows a police officer to search the immediate area, or what the courts deem the wingspan, of the arrestee, as well as the arrestee's person, for any weapons or further evidence of the crime for which they're being arrested for. Okay, so Birchfield v. North Dakota. What happened here? Birchfield is actually a consolidation of three cases. And here's what happened. The first case involves Danny Birchfield, who accidentally drove his car into a ditch on October 10th of 2013. And this state trooper was watching him trying unsuccessfully to drive his car out of this ditch. So the officer pulls him over and immediately notices slurred speech, the odor of alcohol, bloodshot eyes, watery eyes. He was unsteady on his feet. So he asked Birchfield to do some field sobriety tests, and Birchfield agreed. And so Birchfield did these field sobriety tests, and after conducting these field sobriety tests, the officer determined that Birchfield failed these tests. So what the officer did is the officer informed Birchfield that under North Dakota state law, he has an obligation to take a breath test. So the officer gave him this preliminary breath test. It's a roadside breath test that in most states, because of the lack of reliability, they're not admissible at trial. So the officer gave him this breath test, and Birchfield blew a .254, which is more than 3 times the legal limit. So Birchfield was arrested and he was taken back to the station. When he was taken back to the station, he was again notified of his obligation, but now his obligation to take a blood test. And that refusal to take a blood test can result in a crime ranging anywhere from fine to imprisonment. Well, guess what happened? Birchfield refused to take the blood test, and he was charged with refusing. And Birchfield argued that the Fourth Amendment prohibited criminalizing blood test refusals. So the second case happened in Minnesota, and the case involved these 3 intoxicated men on August 5th of 2012 who got their truck stuck in this river while trying to pull their boat out of it. And when the police arrived, these witnesses said that this guy in underwear, who turned out to be William Robert Bernard Jr., was the guy who was driving. So the officer went over, and Bernard admitted that he was drinking, but he denied that he was driving. And after the officer noticed that his eyes were watery and that he smelled of alcohol, and after Bernard refused to do any of those field sobriety tests, the officer arrested him. And when the officer arrested him, the officer took him back to the station, and the officer read him the implied consent advisory that he was told he was required to submit to a breath test, and that refusing a breath test would again submit him to a new criminal charge and penalties ranging anywhere from fines to imprisonment. Well, Bernard refused the breath test and argued that the warrantless breath tests are illegal under the Fourth Amendment. Now, the third case involved Steve Michael Beeland, and a police officer actually spotted Mr. Beeland on the night of August 10th of 2013, also in North Dakota. And he saw him unsuccessfully turn into a driveway, and he almost hit a stop sign before coming to a stop partly still in the road. And so the officer walked to the car. He immediately saw an empty wine glass in the center console. Beeland smelled of alcohol, and so the officer asked him to step out of the car, and when he did, he could barely keep his balance. So the officer arrested Beeland for driving while impaired and took him to a nearby hospital. He was read his implied consent advisory and was told that he was obligated to submit to a blood test. And this time Beeland agreed. The nurse drew the blood from Beeland, and his blood alcohol concentration was .250, which again was over 3 times the legal limit. And Beeland later on argued that his consent was coerced by the warning that refusing the blood test would constitute a crime. So these 3 cases differ in 3 respects. Birchfield and Beeland were told that they were obligated to submit to a blood test, whereas petitioner Bernard was informed that a breath test was required. Birchfield and Bernard each refused to undergo a test and were convicted of a crime for their refusal, and Beeland complied with the demand for a blood sample, and his license was thereafter suspended in an administrative proceeding based on the blood test results that revealed a very high blood alcohol concentration. Alright, so these 3 cases make it all the way up to the United States Supreme Court, and the Supreme Court grants cert, and the Supreme Court limits it to one question: whether or not warrantless blood and breath tests can be justified under the Fourth Amendment to the United States Constitution as a search incident to a lawful arrest. So, because this was something that the founders to the United States Constitution did not envision when they enacted the Fourth Amendment, The court engages in a test whereby the court balances on one hand the degree to which it intrudes upon an individual's privacy, and then on the other hand, the degree to which it's needed for the promotion of legitimate governmental interests. So the court first goes on through an analysis of warrantless breath tests. And the court determines that breath tests do not implicate significant privacy concerns. Well, first, the physical intrusion is almost negligible. They don't require piercing of the skin, and it's a minimum inconvenience. The process just requires the arrestee to blow continuously for 4 to 15 seconds through a straw. And the effort's no more demanding than blowing up a party balloon. And the court also said that humans have never been known to have a possessory interest in the air in their lungs, and the air in their lungs is not a part of their bodies. Also, breath tests are capable of revealing only one bit of information, and that's the amount of alcohol in the subject's breath. And police can't retain a breath sample and test it for further evidence of a crime. Finally, participation in a breath test is not more embarrassing than what an arrest implicates in and of itself already. However, once we start talking about blood tests, that's a different matter, the court says. They require piercing of the skin and extracting a part of the subject's body. And while humans exhale air from their lungs many times a minute, humans don't continuously shed blood. And it is significantly more intrusive than blowing into a tube. Also, in addition, unlike a breath test, a blood test places in the hands of law enforcement a sample whereby they can test it in the future for further evidence of a crime. So the court concludes that blood tests do result in a significant intrusion into an individual's privacy interests. So now, having assessed that, the court now has to look at the interest that the state and the federal government has in these warrantless blood and breath tests. And the court starts off by saying that the states and the federal government have a paramount interest in preserving the safety of the public highways. Alcohol consumption is the leading cause of traffic fatalities and injuries. In fact, in the past decade, traffic fatalities ranged anywhere from 13,582 deaths per year to 9,865 deaths per year. And in the most recent year, 2014, for which the data is available, there were 9,967 fatalities, and that's an average of one death every 53 minutes. So the states and the federal government do have a compelling interest in making sure that they keep drunk drivers off the streets. In addition, there's a small number of judicial officers in lots of rural areas in the various states. And because of that, it would prove to be very burdensome for the states to have magistrate judges available 24 hours a day to determine whether or not there was probable cause for a blood or breath test. So having determined the state's interests, the conclusion that the court came out to was this: breath tests, warrantless breath tests, are justified as a search incident to a lawful arrest under the Fourth Amendment to the United States Constitution. However, blood tests are not. Blood tests, you need a warrant in order to take the blood of an individual under the Fourth Amendment to the United States Constitution, and a warrantless blood test is not a reasonable search and will not be justified as a search incident to a lawful arrest. So what does this mean for our petitioners? Well, Birchfield, who was prosecuted for refusing the warrantless blood test, His conviction was reversed. Bernard, who was prosecuted for refusing the warrantless breath test, his conviction would stand. Beeland, who wasn't prosecuted for refusing a test, but instead argued that his consent to the test was coerced by the state telling him that he would have to submit to the test or be criminally prosecuted, well, the court remanded it back down to the state to determine whether or not his consent was voluntary or whether it was coerced under the totality of the circumstances. So that, ladies and gentlemen, that is Birchfield v. North Dakota. Please drink responsibly, and please, ladies and gentlemen, don't drink and drive.